Thanks so much. I hope that the entree or dessert or whatever I'm serving will be appealing. Actually, what it is a dessert course because it's apples. The title of my program or speech is Apples and Books, or a Gaggle of Googles. You will see how it all ties together shortly, I hope. Arma virumque cano. For those of you who speak Latin, of course, you recognize this as the opening lines of Virgil's Aeneid. Actually, the question for me here is Armageddon virumque cano, which hypothesizes perhaps that we are entering into a phase with respect to libraries that may be problematic. Will libraries of the future look like this? Isn't that handsome? Anybody recognize it? Yes, exactly. It's the Library of Congress. So tell me, O spirit of things to come, is this the fate of our libraries in the future? Anybody recognize this? Ephesus, very good, very good. You get $1. Chicago Mayor Emmanuel announces plans to cut 515 librarians from the city budget. That was an announcement earlier this week. There was an immediate reaction from the Chicago City Council, amazingly enough. 28 out of 50 city councilmen wrote a letter saying, bad idea. I was not personally aware that they'd ever read a book themselves, but at least they were interested in preserving the right for others. So is this the library of the future, perhaps? Spirit, answer me this. Are these the shadows of things that will be, or perhaps only ones that may be? If the courses be departed from, the ends will change. Say it is thus with what you show me. What if there were competition in electronic libraries in the future? Would these be the libraries of the future from which we could choose? Now, this is my moment to give you a little inspiring talk about the importance of competition generally to our country, to our economy, but also to our political system. This quote, the first one here, is from one of the most famous judges of the 20th century, Judge Learned Hand, who said, throughout the history of our antitrust laws, it has been constantly assumed that one of their purposes was to perpetuate and preserve for its own sake and in spite of possible cost, an organization of industry in small units which could effectively compete with each other. A nation of shopkeepers is a good idea. Congress feared concentration of economic power not only on economic grounds, but because of its threat to democratic values. So, this brings us to the Google book case. The Google book case goes on and on. It was not resolved by the proposed settlement, which I discussed with you last year. But I will say that depending on how the case is resolved, it could lead to unpredictable and possibly negative effects on the structure, staffing, and budget of all libraries, whether public, private, or academic. Is that too much to say? I don't know. Why? How? Because it could reduce the ability of current or future competitors to enter the market. Competitors for the service of providing scanned and electronic books. What was the status of the lawsuit, or what is the status of it? 2004, Google announced its print project, which later came to be called Google Books. 2005, the Authors Guild and a bunch of publishers filed suit. There was an initial proposed settlement. It got rejected. There was an amended settlement, and that was taken into account by the court at a fairness hearing in 2010. Hundreds of entities and individuals filed comments, most of them negative, of all sorts of aspects of this proposed settlement. And a little over a year later, Judge Chin, Denny Chin, from the Southern District of New York, who recently had been appointed to the Second Circuit, came back down from on high to render an opinion in the case, rejecting the proposed settlement, concluding that it was not fair adequate or reasonable, which is the statutory requirement. There have been a couple of hearings before the judge, sort of status hearings as to where things are. He basically had sent everyone back to see if they could come up with an alternative. And they reported once again that they have not reached any agreement, but they're making progress and give us more time. Now, what was the court's reasoning? Why did the court reject the settlement in the Google Books case? I'm going to focus really on the competition-related theories that he articulated. There were a number of problems with it, copyright issues, procedural issues, but I want to focus on the competition issues. And principally, what he objected to in this regard was that the settlement was not really a settlement of some misconduct that had occurred. He viewed it, and this was the way the Department of Justice viewed it in their oppositions, that it was a, quote, forward-looking commercial arrangement, unquote. It was a private arrangement of the way people would do business on an ongoing future basis. And the problem that he saw with this was that it created rights that Google would have on a going forward basis, which didn't otherwise exist. And the structure created a mechanism of sharing profits going forward with publishers and authors, and it was not really the resolution of a dispute in the past. It was a new world view of publishing and electronic publishing in particular. One of the things that the judge said about this was that the ASA, that is the amended settlement agreement, would have granted Google the right to sell full access to copyrighted works that it otherwise would have no right to exploit. The amended agreement would grant Google control over the digital commercialization of millions of books, including orphan books and other unclaimed works. And it would do so even though Google engaged in wholesale blatant copying without first obtaining copyright permissions. Harsh words indeed from the judge. The court went on to make the point that while its competitors, Google's competitors, went through the painstaking and costly process of obtaining permissions before scanning copyrighted books, Google, by comparison, took a shortcut by copying anything and everything regardless of copyright status. As one objector put it, the court said, Google pursued its copyright project in calculated disregard of authors' rights. Its business plan was, so, sue me. Turning to the antitrust laws themselves, the judge said that in his view, the proposed amended settlement would give Google a de facto monopoly over unclaimed works. As the United States observed, this de facto exclusivity, at least as to orphan works, appears to create a dangerous probability that only Google would have the ability to market to libraries and other institutions a comprehensive digital book subscription. The seller of an incomplete database, i.e. one that does not include the millions of orphans' works, cannot compete effectively with the seller of a comprehensive product. So, the court concluded with respect to these issues that as counsel for the Internet Archive, which is sort of competitor of Google, said, the ASA would give Google a right which no one else in the world would have to digitize works with impunity without any risk of statutory liability for something like 150 years. The settlement would also arguably give Google control over the Internet search market. The proposed settlement would broadly bar direct, for-profit commercial use of information extracted from books in the research corpus, except with the express permission of the registry and Google. So in the end, the court rejected the settlement and said, look, many of the concerns that I, the court, and the objectors have raised could be resolved if you change this proposed settlement from an opt-out arrangement to an opt-in arrangement, meaning that any authors or publishers with copyrights could choose to include their works, but if you don't get a permission from somebody, you can't just shove these things into your database. So the motion for final approval of the settlement agreement was denied, but without prejudice to renewing it in case they could come up with a better idea. In the 7 months since he issued that opinion, there has been no new settlement idea. And the lawyers, when they appeared before him in September, asked to have matters really effectively adjourned for several months till the following summer. They said they would engage in some discovery, they would continue to work. They were sure they could work something out, but in the meantime, they're going to go forward with some depositions and exchange of documents and things. No trial date has been set, but there is a discovery schedule that runs until the end of next summer. What seems to be the problem with the settlement? Well, what isn't the problem with this settlement? The fundamental structure that had been proposed in the original ASA was so defective in the court's view that there really couldn't be any kind of a settlement that was based upon those kind of theories. Judge Chin noticed that the emperor was actually not wearing any clothes. So, and the problem was that Google wanted to establish, with the cooperation of the plaintiff classes, the publishers and the authors that were involved in the litigation, that they wanted to establish a mechanism that was effectively totally outside copyright law, antitrust law, procedural law, and the judge found that a little problematic. The parties tried to impose a radical rebalancing of burdens and rights. That's my view of it. And the court was having none of it. The opt-in approach suggested by Judge Chin in his opinion seems, however, to be a major sticking point, at least for Google. What is to be done? Well, that's the question a lot of people have been asking. I read a couple of very interesting write-ups of conferences, roundtable discussions that were held over the last few months. One was in San Francisco, another one in Washington, D.C., and they were attended by a lot of lawyers and experts and economists, including a number who were involved in the litigation itself, who got up to give their views as to what ought to be done and how could they reach some kind of a settlement agreement. And without giving away the end of the movie, I will tell you that basically no one agreed with anyone else. If there were 20 experts in the room, there were 21 different ideas. It was summed up, I thought, in the words of one of the speakers quite well. My experience working in this area makes it seem unlikely that we can work this out in our lifetimes. So for those who are on the edge of your chairs as to what's going to happen here, you can sort of scooch back a little bit more. So it's possible that if we wait long enough, things may work out on their own. Time wounds, all heals. Wait a minute, that isn't quite right, is it? Well, in any event, it seems to be that competitors may be nipping at Google's heels. I have read or heard that Internet Archive is digitizing 1,000 books a day. The Hathi Trust digital library includes some 6 million volumes. Europeana links to at least 10 million digital objects from 1,000 EU archives. And Gallica from France is expanding at 5,000 new documents per month. I guess they have slower equipment in France than Internet Archives has, but what do I think? What do I think about all this? I think that all of this competitive activity in the electronic library sphere says to me, let 1,000 points of digitizing shine. And it suggests to me a Rodgers and Hart song, which kind of sort of goes something like this. If they asked me, I could scan a book. But, hey, speaking of books, anybody want a status report on another hot antitrust case involving the world of libraries? You may remember last year I mentioned the Sky River versus OCLC case, which was an antitrust suit that started out in California and then got moved to Ohio. Sky River is, at least from its own description, a bibliographic utility that promotes itself as offering a low-cost alternative for cooperative cataloging. The alternative understood to be OCLC. And there is a second plaintiff, Innovative Interactions, which is a provider of integrated library system consulting and services. What is the beef? The beef is that Sky River and Innovative have taken the position that OCLC has monopolized three markets: the market for bibliographic data about the holdings of libraries, the cataloging of bibliographic records, and the market for interlibrary lending between and among academic libraries. And it is alleged that they have also attempted to monopolize the relatively new market for integrated library systems. Well, did they do something wrong? Well, I don't know if they did something wrong, but this is what the plaintiffs allege: that OCLC requires its members not to share any metadata that it provides to OCLC with any other entity, at least any other for-profit firm like Sky River, and requires them, OCLC requires members to exclusively use OCLC products. That's the allegation. OCLC has also allegedly imposed membership terms of this kind for the purpose of preventing the development of any competing bibliographic databases, cataloging services, or interlibrary loan systems, and is attempting to squeeze Innovative out of the market for ILS services. What's the status? As I say, in July of 2010, the case was filed. It was moved to Ohio, and at the end of last year, in December of 2010, OCLC filed a motion to dismiss. A motion to dismiss is a legal request of the court to look at the complaint and to determine whether it makes sufficient allegations to stand up to the legal requirements of the law. OCLC argues, among other things, that the complaint fails to plead sufficient facts about the conduct by OCLC for there to be a plausible case under antitrust law that there's a violation. In February of this year, Sky River and Innovative filed their response opposing the motion to dismiss, and that's basically where things stand right now. The case has been fully briefed. I should say the motion has been fully briefed. The court has, at the request of the parties, entered an order staying discovery, no depositions, no document research, that sort of thing, until the court rules on the motion to dismiss. It's now been sitting around, so to speak, since February, which is 8 months from 8 months ago, 9 months ago, and so it's probably about enough time for the court to have thought through these things, so we could see a decision on this fairly soon. And the options are either to grant the motion and throw the case out, perhaps allowing Sky River and Innovative to allege additional facts and replead, or the court may deny the motion and let the case go forward in discovery to see what the real situation and real facts are. What will happen? Quien sabe. That, for those of you who speak Latin, are the concluding words of Virgil's Aeneid. Both parties are represented by a highly competent Ohio counsel, familiar with the antitrust laws. I know the guys involved. They're excellent lawyers, and their briefs are excellent. They have articulated both sides of the issue as well as it could be. My own view is that the plaintiff's 39-page complaint is a pretty good job. Whether it's enough to sustain and to withstand the attack launched by OCLC, I'm not sure. But it'll be interesting to see what the court has to say, because the law is a little bit unclear these days as to exactly what you have to plead in an antitrust case in order to get to the next stage, the discovery stage. So we'll see what happens. So what do I think? I think more competition is better than less competition. I think competition spurs lower prices and higher quality and service. So I'm all for competition and for innovative companies. Which reminds me of a song from Fiddler on the Roof. Innovation, innovation, innovation! Thank you. Oh, wait, just one other thing. I can't leave you without saying something nice about Steve Jobs. A special farewell to Steve Jobs, well, farewell meaning kind of R.I.P., for his contributions. He really epitomized innovation in the technological sphere. And to tie it all back to the title of my piece, he gave us Apple. So, apples and books. And of course you see, oh, there it is over there. You see how far innovation and technological databases has gone as St. Peter registers him in the database of heaven.